Welcome to Frank Bruno Law, 6 steps to the probate process. Today is video 3. When last we left our tale, I was discussing the probate petition. So you either need the applicant, the executor of the will, needs a waiver of process. That means if a person consents, the heirs, persons named in the will, if they consent to that person being named and appointed the executor, they would sign a waiver of process, and that is a consent to the probate process. If there is no consent and there's a refusal to sign the waiver, then we will ask the court to issue a citation. Now, along with the petition, there are several other affidavits, sworn statements that are prepared. So an affidavit of comparison, there could be an affidavit of heirship. You would need an affidavit of the attesting witnesses, sworn statements from the witnesses that observed the will execution. So that's the petition and some of the particulars about that. Within your petition, so again, in the order, it really depends. Are we now calculating the fee, or should we have calculated the fee a little bit earlier? Well, it depends. We might not have known all of the assets of the deceased person, but there is a sliding scale. The lowest fee in Surrogates Court is $45, and the highest fee in Surrogates Court is $1,250. $45 to $1,250, those are the numbers, and it is based on the value of the estate. The Surrogates Court Procedures Act, SCPA 2402, has the fee schedule. And sometimes what happens is you might think that the estate is worth, make up a number, $200,000, and you'd pay the appropriate fee, and you subsequently realize there are 3 other accounts, or there's a piece of property that you did not account for, and that brings the estate over the $500,000 mark, and at that point you have to pay an additional fee. You can't fudge the numbers. The numbers are what they accurately are. If you have any aspect of this that you'd like to speak about, please reach out to me, frankbrunolaw.com, frankbrunolaw.com. Wills, trusts, probate, elder law. Thank you very much.